And things are going great. My mom is over COVID.
Very good.
Yes. And I have some other good news. I'm being told that even after I'm gone, the person who's coming in is still going to do YouTube.
Is that
Transparent. Transparency is great. So, yay.
I second that motion, Your Honor.
Thank you. All right, could I see the parties on Christian Allen Ruiz? All right. So the motion for speedy trial for dismissal, before we go on the record, so I can be clear about everything, it is for 2024 CR 008124.
Well, actually, Judge, all the cases are basically the same transaction, so it's going to apply to all of them. I'm sure I filed it in all the cases.
All right, could I see it for all cases, please? And is it there for all cases? Yeah.
I don't see it for. Okay.
All right, court is calling, and you've had a chance to review.
I have, Judge.
All right, court is calling 2024 CR 008124, 2024 CR 008173, and 2025 CR 007834, State versus Christian Allen Ruiz Garcia. Could I have parties announced for the record for the state?
Brandon Prada for the state.
Defense.
Raymond Martinez.
And are you Mr. Christian Allen Ruiz Garcia?
Yes, Your Honor.
All right, defense has filed a motion in each of these cause numbers to dismiss for lack of due diligence and violations of right to speedy trial. All right, defense, it's your motion.
And Judge, I would ask the court to allow me to basically make this argument in all these cases. They're all one series of
Yes.
events that all happen together, so
Any
it
objection?
wouldn't be any
None from the
difference.
state.
All right, you may proceed, counsel.
But Judge, the court will recall, and I'll also bring up that one of the reasons for today's setting was to bring the defendant, who was a juvenile who's now in TDC, to court because we want him to testify in our case.
Mhm.
We can't even accomplish that because nobody has his birth date. I don't have access to his birth date.
Mhm.
State, and I'm assuming Norma was never able to
All right, and the
obtain
court
that
will,
information.
the court will note for the record that a defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024. Specifically, well, I thought I had the specific date, but I don't, but the court has it before it. It's in June of 2024, Judge. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. A critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, I think everybody can agree that he's in essence a co-defendant, was charged in juvenile court.
And
And
just one moment, state, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juveniles and since it was a certification, he was then sent to TDC, which we believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking from the very beginning, because he's a co-defendant and because he has his own set of discovery, and more importantly, in this case, he had other aggravated robberies in addition to the ones that were with my client. So our theory was, when it was our theory, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case, the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to help support our suggestion that he was operating under under duress. But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they in fact appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, judge, we refuse to do
Mhm.
what you're telling us to do. Okay, so we stepped back from that and we regrouped. we found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. He denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client, but we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, the juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. Not sure they even got filed on.
And when you say other cases, you're speaking about your client's co-defendant.
Correct.
All right.
The co-defendant had double-digit number of aggravated robberies. And so the ones they chose to prosecute didn't coincide with my client's case, unfortunately. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need. But we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of court, I will tell you that his advice to this client is going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even if we were able to get him here, I don't believe we would have been very fruitful.
All right.
But
And the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and no one had any objections to the prosecutors zooming in. And they informed the court that they would not comply with discovery. And so state, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. Under 3914, if it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office. So everybody's responsible for discovery.
Judge, sorry if I could just
Yes.
chime in here, but I think like the
And
distinction.
if you could announce.
Yes, it's Megan Galloway for the record. The distinction in this case is that there's a legal reason why it's not being provided.
Mhm.
I believe under the family code, it's protected because the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other. So we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say the petition to the juvenile court was still made. And that court determined that it should not be turned over. And so at this point,
And I know that the prosecutors in this court did all they could to get the information to defense. Is that correct? The attorneys in this.
In this court, of course, Judge, and
Yes.
I don't dispute anything the council just suggested to the court, but that could have been avoided.
Mhm.
When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187, say, hey, we're getting ready to go forward on this guy. This is our deal. We're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's
Yes.
being presented before me. And I want the record to be clear that the prosecutors in this courtroom did all they could to obtain the information that you were requesting.
I'm not disputing that, Judge.
And what I will say again, it appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. But I just want the record to be clear that the prosecutors in this court, I don't think, I know that you all did all you could to obtain the information.
then Judge, just to address one thing, the date of birth of the co-defendant was provided in the discovery that we received. So
Okay. He should have that.
has
Okay.
that.
All right.
Um,
And I understand what you all are saying about the bench warrant with that. But we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we really doing? He can't present his defense, and nobody knows, for the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that potentially.
It would help us to prove that point, we think, Judge.
So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw, because I mean, that was his ruling. So at this point, my hands are tied because that was his ruling under the family code.
Mhm.
And I would agree that neither party knows what is in those records that are over there. However, if we're getting to the point of, or their argument of duress, there are pieces of evidence where, in this case, that were turned over, like statements from the defendant that do address that if they would like to put it forward.
All righty. Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Thank you.
Your Honor.
All right. Arlene Gay, you're here?
Yes, Your Honor.
Kevin Williams? Hello.
Morning, Judge.
Good morning. Let me see. Odyssey is moving slow. All right, so where are we on to the discovery with phone records, restitution amount and all of that?
We have received a majority of the items that were missing last time, Judge, but outstanding. Defense would like me to determine the time order at which 911 calls came in. There is potentially a missing statement of a witness and then some text messages that
may or may not be missing that I'm gonna send an email right now and determine.
All right, how long do you need?
At least 2 weeks, Judge.
All right, Ms. Ferguson, I need a recall for discovery for 3 weeks.
Yeah.
And this will be final discovery. And state at that time, you need to be prepared to tender an offer.
Yes, Judge.
All right, thanks, state.
Thank you.
What date?
March 30th.
All right, we'll see y'all back on March 30th.
Thank you, Your Honor.
All right, we're back on the record in 2024 CR 008124 and 2004 CR 008173 and 2025 CR 007834 State versus Christian Alan Ruiz Garcia. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. And it'll be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
Thank you, Your
Excused.
And counsel,
Those other
make
orders.
sure the
Yes.
court has all the motions,
I'll follow up with the clerk after a while, Judge, or make sure they get submitted.
because I only see one and maybe it's lost somewhere in the system.
And I may have copies. I'll bring it back.
Jimmy Robles.
Very good.
Good morning.
Before
Hi.
we
Where's-
move on the record, I just want to introduce the clinic students.
Hi, how's it going? So what year are you guys?
The 2L.
Oh, awesome. Yeah, I was at St. Mary's Clinic. That was one of the reasons why I chose the law school. Yes.
Yeah, it's been a great experience.
Okay, awesome. Cindy, we're going to go on the record so the students can have their announcements on the record. All right, court is calling 2026 CR 000714 and 2026 CR 000715 State versus Jimmy Robles Reyes. Can I have parties announced for the state
Brandon Brady for the state.
defense?
Adi Chavez. Defense.
Philip Gonzalez.
And Aaron Diaz.
All right. And you are Mr. Robles? All right, so state, where are we on discovery?
Judge, I was just looking at Veripic and it looks like all body cameras on there. I think that we might be missing something in regards to medical records. I'll have to check if there are any medical records that exist. But I think we just need to reset for discovery.
All right. Do you know of anything outstanding other than medical records?
Judge, there was a sergeant that was there. We have his dash camera, but we don't have his body camera.
Okay, so body cam. Anything else?
And then there were also additional officers that arrived afterwards, and we don't have any camera from them.
All right, state, and they say there were additional officers with, is this body cam as well or body cam and dash cam?
Body cam and dash cam, Your Honor.
All right, any other discovery that you're aware of?
No,
Do
Your Honor.
do y'all have the 911 calls? Were there 911 calls?
There were no
No,
911
Your Honor.
calls.
All right. So Ms. Ferguson, I need a 30-day reset for discovery. All right, so we'll be back on April 9th. If you all can confer off docket to make sure that you have the discovery. Yes, because we're off the record now. So are you guys still in school in the daytime?
Yes.
So you won't miss too many subjects. So are you all both thinking about criminal law?
Yes,
This is what you want to do. Is it your passion though?
it is.
Because this is not a profession where you're going to become a multimillionaire, but it's a labor of love.
I don't know.
All right. Well, we'll be back on April 9th. So once your client signs the reset form, he'll be excused. Thank you for dressing appropriately for court. All right. Thank you.
Thank you,
Awesome.
Judge. Nice to meet you.
You too. You guys have a great one and come by anytime.
Thank you.
Thank you,
You're
Judge.
welcome. Eric Talamontes. Hello, how's it going?
Morning, Your Honor. How are you?
Well, I'm doing great. I cannot complain.
Morning, Your Honor.
Good morning, Eric.
Yeah. Okay, quick question.
Yes.
So I heard your comment about the YouTube thing this morning. Didn't that judge kind of run against you saying she wasn't gonna take a shot? Sorry.
Keep your
comments to yourself. I was asking.
Well, no. Yeah.
I'm sorry. I was.
Well-
There's not a place for it. No, I'm sorry. It was
Mhm.
actually- I apologize, Your Honor. Not a place for it.
Yeah.
No.
But no, that's fine. He's fine.
Oh, you did?
All right.
Yes, to answer your
Some people
question.
can't help themselves.
Mhm. But yeah, I had said Erica at first because the A was,
Yes,
Next
yes,
to the
yes. I get
C.
that a lot.
yes. So where are we on discovery?
You know, I'm just talking to the state and she was looking into it. I have a whole slew of discovery. But an injury has been alleged and I don't see medical records in there.
Okay,
I'm
medical
sure-
records.
Yes,
All right, State, if you can check to see maybe if there's some medical records.
Judge, they're not in the system. I'm trying to look over the case to see if the complainant went to the hospital.
Okay. And then the okay, the other case is a misdemeanor. So what we'll do, Miss Ferguson, set this in 30 days and State, were you able to tender an offer or no?
no, not yet. No.
No, Judge.
And State, if there's anything in existence, you think you'll be able to have it by April 9th?
Yes.
Or at least know if it's,
Yes.
all right, so on April 9th, offer will be due.
Okay.
All right, we'll see you back on April 9th, okay?
Yes, ma'am.
All right, thank
Thank
you.
you.
Once you sign the reset form, you're excused.
Okay, thank you so much.
Thank you.
Thank you.
All right. Jorge Gasada.
Great, Judge.
Nothing, nothing very long.
All right,
Just
Miss,
that way I can look into that issue.
all right, Miss Ferguson, can we recall this for next week, Thursday?
Yes, Judge, but in the meantime, my client has a request. He's still in federal custody, Judge. He hasn't, his sentence is set to expire this year, matter of fact, in a few months.
Mhm.
He's asked me to ask the court if he could appear by Zoom for that next setting. Because if the case is going to continue to go forward, he'd like to be able to post bond on this case and defend it the way we normally would. He's got literally the last few months of his sentence. in
Yeah.
federal.
No. All right, Thursday, Miss Ferguson?
Yes, ma'am.
Is everyone okay with Thursday?
I'll be here, Judge.
Thursday will work.
All right, we'll have you all back on Thursday.
And right,
Okay.
That's the 19th.
Okay.
Sounds great.
Thank you, Your Honor.
All right, you're welcome.
Thank you, all.
No, just
Motion.
Yeah.
Motion. to dismiss.
Okay.
Jessica Navarro.
We're in there, Judge.
All right. So where are we on discovery?
Judge, this is our first setting on this, I think. I'm pulling discovery on it right now. We're trying to figure out exactly who's got this file. I
Yes,
spoke-
I'm sorry,
No, go ahead.
just to assist, it's a peculiar charge, Your Honor, and we're trying to determine if it's family violence charge or if it's a CTD charge. We couldn't find the file and that's not in their box either. So we need to determine that and yes, I need to, if it is going to be ours, I need to make sure that all discovery has properly been uploaded for him. So
All right, Ms. Ferguson, recall this in 2 weeks.
Thanks, Judge. We should be ready to do something with it. I think at that point, we've got some pretty good progress this morning on the client, so hopefully.
All right, we're coming back on March 23rd.
Yes, sir.
Perfect. It'll work. Thank you, Judge. We'll see you then.
All right, once you sign, you're welcome. Once you sign the reset form, you're excused.
Yes, Your Honor, thank you.
You're welcome. All right, Emilio Longoria. All right, where are we on discovery?
Your Honor, discovery is complete. I have a discovery acknowledgement for the court.
Has an offer been tendered?
Yes, Your Honor, we received an offer today.
All right, and sir, how old are you?
89?
39?
Yeah.
All right, Ms. Ferguson, set this for a plea deadline date in 3 weeks, please. All right, once you sign the reset form, you're excused.
You're good. You're good to go. You can sit down. I'll bring you the form. Thank you. Thank you, Judge.
You're welcome. Servando Menchaca.
See discovery.
Thank you.
Oh, she's coming. Thank you.
Morning, Judge.
Good morning. Good morning. And state, in this case, have you tendered an offer?
Yes, Judge.
How old are you?
31.
All right, Ms. Ferguson, set this in 3 weeks for a plea deadline date.
Yes, that would be March 30th.
All right, we'll be back on March 30th. At that time, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not, your next setting will be a trial date. All right, thank you.
Thank you, Judge. Maybe we excuse.
Once he signs the reset form.
Yes, ma'am.
All right, thank you. All right, Michael Castillo. On this case, what is happening?
Judge, he has two charges. One is a possession charge that came out right at 1 gram.
Mhm.
He has a family violence case. The problem is the state cannot give me an offer on the family violence because the victim, I guess, has a charge against her and she has a lawyer. And they need to, if I'm not mistaken, they need permission from that lawyer to speak to the victim.
That's correct. The victim has her own criminal charges pending.
And
that
who's the attorney?
Eric DeWalt.
Oh.
He hasn't responded back to me yet to grant me permission to talk to him. So until I can talk to the victim is when I can give an.
All right, Norman, can you call Eric DeWalt?
Yes, sir.
All right, so she's gonna call Eric DeWalt before you all leave here and see if she'll allow you all to talk to the client.
There you
Then
go.
we're gonna recall this.
That'd be great, but
All right, so are you all okay with recalling this in 3 weeks?
fine with me.
Just remember, you gotta do it before the 24th. I've got.
All right, Norm, I need this called back before the 24th.
The 19th.
All right, the 19th.
Judge Registrar Adwell.
All right, just bring him up.
Mr. Adwell?
All right, thank you. All right, so were you able to find the discovery with the surveillance?
No, Judge, it's my belief that it does not exist. I've emailed SAPD, assigned detective, but also the regional Home Depot people, and they have not provided me any and not indicated of its existence.
All right, and then the other thing, has an offer been tendered?
Yes, Judge, it was tendered via email on February 13th.
All right, sir, how old are you?
54.
All right, Ms. Ferguson, set this in 2 weeks for a plea deadline date, please. All right. For a plea deadline date.
We can do March 23rd.
All right, we'll come back on March 23rd.
ma'am.
At that time, you need to let the court know whether or not you've reached agreement. If you have not, it's going to be a quick turnaround for a jury trial. All right, thank you.
Thank you, Your Honor.
Counsel. Good
Thank
luck
you.
on your trial.
Just have a seat, sir.
Judge, present for Nathaniel Casino.
Mhm.
He is not here right now.
So where is he?
I don't know at this point.
All right.
There's a
Date?
big order.
Court is calling 2025 CR 016043 State versus Nathaniel Pacina. Could I have parties announced for the record?
Lauren Espinoza for the state.
Martin Getta, attorney for Mr. Casino.
All right, this hearing was scheduled at 9 a.m. It is now 11:15 a.m. Deputy Laura, did you make an announcement?
Yes, sir. I did negative contact.
All right, so first, have you had any contact?
No, Your Honor.
All right, state.
We would be requesting a bond forfeiture, Your Honor.
All right, the court will issue a judge's warrant and remain your client without bond.
Thank you, Judge.
Thank you. Court is calling 2025 CR 012-615, 2025 CR 012-621, State versus Francisco Alvarado. Can I have parties announced?
Lauren Espinoza for the state.
Robert Barron for Mr. Alvarado.
And are you Mr. Alvarado? You entered a plea in each of these cases. Is there a PSI and TAP evaluation?
Oh, the PSI, I'm not sure about a tap, Judge. We were here last week and you
Yes,
were gonna bring him back Friday and then brought him back today.
yes.
I don't think there's a tap.
I have the exhibit.
I'm sorry.
I have.
Yes, there is a tap.
All right, is there any other evidence that either party wishes to present to the court?
Not at this time, Your Honor.
Judge, Mr. Alvarado would like to make a statement if you care to swear him in.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Francisco Alvarado.
All right, defense, you may proceed.
Okay, you wanted to make a statement to the judge?
Okay, everyone, please whisper.
I'll speak loud enough so this way you can hear everything you say, okay? All right, go ahead.
I just wanted to say that this was a terrible mistake and something that I will never come back to. And I just hope after this I can get my life back on track and continue on what I was doing. Is I live and learn, and I will not go back to anything I did.
Any questions?
No, Judge.
All right, I have a question if there's no objection.
Sure, Judge, go ahead.
All right, from State's Exhibit number 1. It appears, oh, this is,
That's the right one?
no, this has Courtney Price on it.
Oh, that's the other
I don't
girl over
believe we
there.
tendered any exhibits.
No, yes,
Yes.
yes, I was,
Oh, yeah.
Only
Oh, that's
like our
right. It
stipulation.
wasn't the
but-
plea, that's right.
okay,
I'm sorry.
it's okay, I was like, I thought my steel trap was failing me because I was like, I don't remember, maybe I'm wrong.
And Judge, just, Mr. Alvarado's parents are here in the courtroom and his support of him. I've spoken with them as well. They've said they've never had a bit of trouble from Francisco before this. And
Mhm.
they're very out of character for him, and he's told me the same thing. And as I told you the other day, he's been nothing but respectful. And other than showing up at 11 the other day because he got multiple messages from his sponsor telling him so, he's been here at 9 o'clock every other time. And we really ask the court to grant his application for deferred.
All right, I do have some questions. Where are the items that were in the vehicle?
Where are the items?
Mhm.
Of what items?
The person's grandfather's ashes.
I didn't touch any of that. Everything that was in the car was left in the car.
So who took items from the vehicle?
I didn't, Your Honor. I didn't touch anything. Everything that was in the car was left in the car. So,
All right, how did you obtain this vehicle?
we had got it. One of my buddies did, and I ended up with the keys and just ended up joyriding it.
No. I mean, you're skipping over some things. Counsel, do you want to ask some questions about that? Like how he ended up with this vehicle? Because with regards to the PSI, they're saying some sentimental things are missing. And I'm trying to figure out where these items that were in the vehicle.
When this, where did this happen? Where did you see the vehicle first?
I seen it here in San Antonio.
Well, I don't mean that. I'm be more specific. Where?
One of my friends had it.
Okay. He brought it to your house? You went to his house? What?
Yeah, he brought it to my house.
Okay. And then you ended up driving from there? Or
Yeah, he ended up giving me the keys and I ended up driving it after that.
Did you inspect the contents of the car at that time?
I did not.
Okay, so before your friend brought it over there, who is this friend? What's his name?
Jaden?
Okay. Or Jaden brought it over there. Possible that some things in the car may have been taken by him?
As far as like ashes and all that, I don't think he would touch any of that, but I know I didn't grab any of that.
Well, I mean, when you got the car, did you immediately get in and start driving?
I did.
Okay, and how long was it after that that the police tried to pull you over?
Like 30 minutes.
Okay, but you'd been driving the entire time?
Yeah.
You didn't stop anywhere?
No.
You didn't stop to open doors or look in the trunk or anything like that? So you're just driving around and around? Okay. And once you were pulled over, you no longer had anything to do with the vehicle at that point, is that right? When you were being pulled over, do you know if you or your friend Jaden or anybody else that may have been in the car was throwing things out the window or? And I don't think there's any evidence of that, Judge, either, but just thought I'd ask.
Any questions? All right, so let me just tell you, you said that these are, you know, you made a mistake. No, these are choices. You understand? These are not mistakes. These are choices you made, and that's why you are here. How old are you?
23.
So this person says that the total amount that they're able to account for is $5,000.
For, I haven't seen anything about restitution, Judge, but I'm glad to have a hearing or inspect the,
I mean, they're asking for $5,000 restitution. So is there going to be any objection to that $5,000 restitution?
no, Judge.
All right. State, unless there's anything else, you may be excused.
Thank you, Judge.
Thank you. And cause number 2025 CR 012-615. The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's to be proof of employment within 45 days of release. No employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month for 6 months. There's to be restitution of $5,000 to Demarion Jasmine. There's going to be 200 hours of community service restitution. Do you have any children? All right. The court is going to order the felony theft course. Once that's completed, the community service hours will be deemed satisfied. And this is the run concurrent with 2025 CR 012-621. Probation, is there anything else with regards to that cause number?
No, Judge.
And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because that's a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And cause number 2025 CR 012-621. Court will find you guilty. Court will sentence you to 6 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. This will run concurrent with 2025 CR 012-615. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, no unsupervised contact with minors. 200 hours of community service restitution. The court is going to order the defensive driving course. Once that's completed, the community service hours will be deemed satisfied. There's to be no driving without presenting to probation proof of a valid license and insurance. There's to be field visits one time per month for 8 months. And there is to be supportive outpatient treatment with probation. And probation, if you'll test for levels. Probation, is there anything else? Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you.
I confer with Renee.
Uh-huh.
We've got some information, so it's gonna be difficult to find out. There might be some more intensive treatment / supervision
Mhm.
that we get him that may allow him to be in a better position once he goes home.
Mhm.
Because it seems that when he's on his meds, he's okay.
Yes.
That's our concern, is he's not on his meds.
Mhm.
And if there were programs through
Crystal Counseling can provide case management as well as make sure he's med compliant. And they do take insurance such as Medicaid, which Mr. Howie may qualify for to address the root cause of that issue. And from speaking with Mr. Martinez, it seems like if he gets a hold of that issue, becomes medication compliant and has access to case management services, that we believe his issues in the future will be non-existent essentially.
All right, so we're gonna go on the record. Court is calling 2018 CR 4056 State versus Kenneth Howie. And for the defense?
Louis Martinez.
All right, this is a case involving the Attorney General's office. The Attorney General's office were given notice of the hearing. They did send an email to the court. Defense counsel is in receipt of that email, and the Attorney General's office is objecting to Mr. Howie moving back in with his mother. From the court's reading of the email, the concern is that when Mr. Howie leaves inpatient treatment, that he no longer takes his meds. So it's been addressed with the court that we may be able to accomplish his living with his mom and then having a case manager. Is that correct, defense?
That's what we believe, Judge.
All right, so this is what I'm going to do. And I know that he's been at Lifetime, is that correct?
No, he's been at Crosspoint.
I'm sorry, he has been at Crosspoint and his treatment there is complete. So what I'm going to do, I will allow him to move back in with his mother. There's to be you're welcome. There's to be no contact with the neighbor that is a subject of this, subject of some of the issues. And then we're going to recall this, and we're going to call this in 30 days. And Mr. Howie, you're going to be present in court with your attorney in 30 days. And at that time, I'm going to expect some movement on his obtaining a case manager through Crystal Counseling.
Yes, Your Honor.
All right, Ms. Ferguson, I need a 30-day reset. So. All right, Mr. Howie, just give us one moment.
Yes, ma'am.
All right, Mr. Howie, do you have any questions?
Yes, ma'am. Will I be allowed to leave the facility today if you get a hold of my probation officer?
Probation is actually here. So what we'll do, just hang on. I'm gonna put you in a breakout room.
Okay.
All right, and counsel, if you can zoom in into the breakout room with them.
Mhm.
All right, thank you. Victor Guzman. All right, counsel, where are we on discovery?
I believe that the state reached out to the AUSA that we were talking about, some federal involvement in the offense. And the state was told and confirmed by the federal prosecutor that they did not have to do anything with this specific transaction. There's another case that involves the defendant, but it's not from here, and they have nothing to do with this. That's my understanding.
That's correct.
So you have all discovery?
I should, Judge, yes.
Has an offer been tendered?
Yes,
sir.
yeah, yes, Judge, it has.
All right, sir, how old are you?
21.
All right, Ms. Ferguson, set this in 45 days for a plea deadline date. All right, we're going to come back on April 28th. At that time, you need to let the court know whether or not you reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial date. All right, thank you.
Thank you, Judge. Maybe excuse.
Yes,
Maybe it's your end.
yes.
Thank you.
All right, so on Jason Donahue, that's coming back at 1:30 for jury trial. All right, Higgins.
Ready to approach?
Yes. Hey, how's it been going?
Good, you? Well, we'll talk
great.
later.
Oh,
Yes.
no. It's great. And then I'm always looking at you and seeing where you traveled somewhere. I'm like,
Yeah, I'm leaving soon. I don't know where.
oh my God.
It's
See?
called Trip of the Month Club. So when you get to a certain age, you have to assign a trip of the month so that you can survive the rest of the month going on a trip.
Yeah, hey, I love it.
That's a good policy. I like that.
I've been practicing 39 years. I should do something.
Yes.
Richard Garcia is work once a month.
Yes. All right, the court is calling 2025 CR 015736 State versus Marielle Higgins. Can I have parties announced?
Joanne, that was for the defendant.
And are you Mr. Higgins? All right, counsel, you received all discovery. Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Higgins, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Higgins, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is my belief, Your
Do you
Honor.
believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Higgins, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, no.
Anyone promised you anything other than the plea?
Oh, no.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine to be probated, and the state recommends deferred. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be 100 hours of community service restitution, the DOEP course, and MRT. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
So the offense, how do you plead then? State, any evidence?
Judge, you have 6-1 on all attachments.
You want to review the same? We have no objections.
Right, State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we waive the PSR.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. My client enrolled in the HOPE program for the city 9 months ago when he was arrested. He's done at least 9 months worth of programs and can provide proof to the probation officer, including parenting classes, anxiety, mental health. He had some mental health issues, PTSD issues. He'd asked the court that in that program, they have picked him to go to a research program in September in Houston.
No, it's gonna be they're taking us to California, and it's actually a whole year that I've been participating in this program. It's a 365-day program. It's for the kids and their father or parents who've been through tragedies and seeing how the kids' minds work and whatnot. So they're sending us out there to go do some more research on that.
And so he'd be asking permission to go follow through with that research in that
And it
program.
won't be till around August, September time. I don't have the exact date, but they just, I go Thursday for my 1 month meeting because I still participate in the counseling Israel.
And is all of this through the HOPE program?
HOPE
San
program.
Antonio Hope Center, yes, ma'am.
Okay.
And as he's asking also because of that, he would ask if you give any consideration on the CSR. He's worried. He is a parent of small children. And so
I have full custody of my 6-year-old son. His mother is actually hasn't been here since he was 3 weeks old. And I work a full-time job. And between that, I'm just trying not to shoot myself in the foot. So I don't know what shot I'll make until I shoot it. So just seeing if I can get accommodation for that.
All right, let's go off the record. Okay. All right, the court is calling 2026 CR 0000096, 2026 CR 0000217, and 2026 CR 0000214, State versus Courtney Price. Can I have parties announced?
Frank Griffin, State.
Richard Garcia for the defense.
And are you Ms. Price?
Yes, ma'am.
All right, we were here previously on a motion seeking bail reduction. And the court did not make a ruling because the court was not presented with any information on a bond amount that the accused could potentially make. So is there any other evidence to be presented to the court?
Yes, Your Honor, we brought in a lady by the name of Pierre Harrison.
All right, is your come forward?
Ms. Price.
All right. Would you raise your hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Pierre Harrison.
All right, you may proceed.
Thank you. Ms. Harrison, how are you related to Courtney Price?
A friend.
And is it true that you brought 2 cashier's checks today to present to the court as proof of Courtney's financial ability?
Yes, sir.
And can you tell the court, do you have those checks with you?
Yes, sir.
Do you have them?
Oh, you can just tell me the
Okay.
amount.
Oh, I believe one is for 10,000, the other one is, well, one is for $9,818 and one is for $750.
Okay.
So it's roughly $10,800.
Yes, sir.
And Ms. Price has signed these over to you,
Yes, sir.
and that's so that you can pay her bond?
Yes, sir.
And have you been to a bonds company?
Yes, sir.
Can you tell the court what's the name of the bonds company?
AAA Rick's Bond.
And do you know if Ms. Price has any more financial resources to pay the bond?
She has me.
Excuse me?
Me.
Are you able to help her pay the bond?
Yes, sir.
And how much can you afford?
I will be able to afford whatever she needs. I can cover the back end of whatever she's to bond out.
So if the judge were to lower the bonds by $100,000, it would still be 150,000, so you would need about 15,000. Are you prepared to help her with about $4,000, $5,000?
Yes, sir.
And are you working right now?
Yes, sir.
And you have this money saved up, or
Yes, sir.
and are you? I don't know if I asked you. Are you willing to help Miss Price
Yes, sir.
by lending her this money?
Yes.
Thank you. That's what.
Any questions?
That's it.
All right, thank
Hold
you.
on, hold on.
No further questions.
Okay, thank you.
All right. And both parties have already informed the court that all of these cases arise out of the same alleged offense. Is that correct?
Yes, Your Honor.
All right, this is what the court is going to do. And cause number 2026 CR 000217. The motion for a bond reduction in that cause number will be denied. And cause number 2026 CR 000214. The motion for bond reduction in that case will be granted and bond will be reduced to $80,000. And there's to be no driving. And if it hasn't been done, there's to be ignition interlock on every vehicle that the defendant has access to. And then in cause number 2026 CR 000096, motion for a bond reduction is denied. And then where are we on discovery in these matters?
Judge, I'm still missing some discovery in the 2026 CR 00096 that is forthcoming.
Yes, Your Honor. Briefly for the record, with that charge, I was getting on the family violence. Just came to our attention today that we previously disclosed records of the hospital related to the child.
All right, what we're going to do is we're going to reset this discovery then for 45 days. Norma, I need a reset date, 45 days for discovery. Oh, thank you. The 28th,
What day?
April 28th. All right, thank you.
Thank you, Judge.
Are you all ready on Higgins? Okay.
And we've initialed the changes.
All right, thank you.
Explained it to my client prior to that.
All right, thank you. So we're back on the record in 2025 CR 015736. So the state is proceeding on the lesser included offense of attempted possession of a controlled substance, penalty group 1 less than 1 gram. That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine. Do you understand?
Yes, ma'am.
All right. State, you may be excused.
Thank you.
And as previously stated, the court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing counsel?
Yes, Your Honor.
Okay. So this is what the court will do. The court will sentence you to 6 months deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, continued participation in the HOPE program, and you to provide proof of that. There's to be 100 hours community service restitution I'm going to order parenting classes. Once that's completed, the community service hours were deemed satisfied. The court will note for the record, the defendant has stated that he's receiving parenting classes through the HOPE program. Probation that can count towards that. Field visits one time per month for 2 months. If you're drug tested today, what will the results be?
Oh, no, it'll come out dirty.
I'm sorry,
It'll come out dirty.
for?
Marijuana.
Okay. So that's going to be, instead of 6 months, that's going to be 1 year deferred adjudication. There is going to be supportive outpatient treatment with probation. And there's going to be field visits one time per month for 6 months. And probation do a TAP evaluation out of custody. And on the UA's test for levels. All right, probation, is there anything else? Is there anything else you need from the court?
Oh, sorry, Judge. I did hear mention of possible going out of town.
Yes, I was about. Since.
Until September.
So he's allowed to travel for participation in the HOPE program.
Thank you.
All right, thank you. Anything else, probation? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? You're gonna have to start making better decisions.
I've already been on 9 months.
All righty. All right, thank you. Court is calling 2025 CR 013249 and 2025 CR 013246. State versus Matthew Luna. Can I have parties announced?
Paul Acevedo for the defense.
And are you Mr. Luna?
Yes, ma'am.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, I have, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Luna, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor, I do.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented in the cause number ending in 46?
No, Your Honor, state moves to waive count 1 and proceed solely on count 2.
We have no objection, Your Honor.
And the cause number ending in 49, are you proceeding on the indictment as presented?
Yes.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
All right. And the cause number ending in 46, you're charged in count 2 with possession of a controlled substance, penalty group 1, less than 1 gram. And the cause number ending in 49, you're charged with offense of possession of a marijuana, 5 pounds to 4 ounces. Each of those offenses are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am.
In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
I feel he does, Your Honor.
In each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Luna, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, according to the plea, there's to be $1,000 fine probated. The cases will run concurrently. The state will take in consideration 2025 CR 013252. State is recommending deferred adjudication. And in the cause number ending in 46, the state is proceeding on count 2 only. Did you understand that to be the plea in each cause number?
Yes, Your Honor.
Defense?
That is the agreement as we understand it.
State? Did you review the waiver of appeal paragraph in each cause number? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement in each cause number, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours community service restitution, the DOEP course, and MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
And the cause number ending in 46 to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in 49, how do you plead? Guilty, not guilty, or no contest?
Contest.
State in each of the cause number, any evidence to support the defendant's plea?
Yes, Your Honor, sheet offers states exhibit 1 in all attachments of both causes.
We have no objection, Your
All
Honor.
right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would just like to say that he has expressed remorse to my office. He's accepted responsibility. He is gainfully employed. He's working 2 jobs right now, and he's interviewing for a job that is much better than the one he has right now. I would ask the court to consider giving him the deferred adjudication.
All right, and what do you do?
I work construction and landscaping.
Okay, do you have any children?
No, ma'am.
Do you live by yourself or with someone else?
By myself, Your Honor.
All right.
Well, hold on, be completely honest. He does have a girlfriend that he does support.
Mhm.
Now, they don't officially live together, but he does support her. She does not have any children, and at least no children, Mr. Luna, but he does help support his girlfriend.
Okay. And the cost number ending in 46, the court will sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs. If you're drug tested today, what will the results be?
Clear.
All right. There is to be 100 hours community service restitution. I'm going to order the the MRT class. Once the MRT is completed, the community service hours will be deemed satisfied.
Thank you, Judge.
Proof of employment within 30 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 8 months. $1,000 fine, that will be probated. Take in consideration 2025 CR 013252. And this is to run concurrent with 2025 CR 013249. And there's to be a TAP evaluation out of custody. And probation, if at some point in time he tests positive, then the TAP recommendations will be followed. Probation, is there anything else? And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Yes, Your Honor.
All right. Next, we're moving on to 2025 CR 01349. Court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider with minors, field visits 1 time per month for 8 months, $1,000 fine, probated, taking in consideration 2025 CR 013252. This is run concurrent with 2025 CR 013249. And there's to be a TAP evaluation out of custody, hold recommendations in abeyance unless the defendant tests positive. Is there anything else you need from the court?
Nothing further, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Oh, I'm so sorry. One other thing in those, and that cause, Gabriel Preto Hall, do you know him?
Yes, sir.
Are you all still associating with each other?
No, ma'am.
All right, Ms. Abrams, there's to be a no contact with Gabriel, Gabriel, Preto, Prieto, last name Cravalho. All right, thank you. Good luck to you.
Thank
Have
you,
a good
Judge.
one.
Maybe Vikky.
Thank you. God bless you too. Romero? All right, court is calling 2025 CR 015517, State versus Juan Romero. Can I have parties announce?
State.
Christopher Ramos for the defense.
And are you Juan Romero?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that state is in compliance with discovery. Mr. Morero, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do.
State proceeding on the indictment as presented?
Yes, sir.
All right, did you review the court admonishments and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged by indictment with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Romero, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
And if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,000 fine. State is opposed to your applications. This is run concurrent with 2025 CC 003749. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Yes, Your Honor. State of State's Exhibit 1 in all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
So,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
so,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. So the case that's being taken in, I'm sorry, the case that this is running concurrent with, is that the same, out of this same occurrence?
That case, the FTR case, that, yes.
The DWI.
DWI. that extends.
Okay. All right, and so state you're opposed.
Yes, Judge, state is opposed. As you know, based on the stipulations, this case has an associated driving while intoxicated. Mr. Romero has fled on that case, and just 3 months into that probation is facing a motion to revoke for not only technical violations, but also a new alleged number 1, which is out of county. So because of that, it's the state's position that he is not a good candidate. He's shown he's not a good candidate. And also he's failing to comply with the rules and regulations set out by probation, and failing to comport his behavior with those documents. Because of that, we do not.
All right, and what is the out of county case?
Alleged to be a driving while intoxicated. Out of house.
Do you know what's happening with that case, counsel?
Atascosa case, no, Judge. I can offer that this case is associated with the case that he was on probation for from last year.
Mhm.
We placed him on probation for that case last year out of the county court. This seems to be a result of maybe some of delayed testing and delayed indictments. It does seem that he does have a chronic drug issue, substance issue that's contributing to this behavior. I can't speak to the Atascosa County case on the MTR. I mean, I haven't seen the discovery and I'm not on that case, so I can't really speak to that, Judge. I can offer that it does seem that he's plagued with substance abuse issues.
All right. Are you waiving your PSI?
Yes, Judge.
Okay. Anything else to add, state?
I would just add, Judge, that it is of high concern that probation requirements first ordered ignition interlock. That was then amended to do an affidavit of non-driving. So obviously that was not complied with here.
All right, the court is going to find you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs. Are you currently employed?
No, not at the moment.
All right. There's going to be
But I am looking to get in the union for electrician. I already started the 10-hour OSHA videos, and well, that's what I need so then I can start getting calls from the union.
And if you're drug tested today, what are the results going to be?
Probably positive for weed.
All right. All right, this is what the court is going to do. There's going to be a TAP evaluation. It's going to take place in custody. And follow TAP recommendations. And there's going to be a referral to felony drug court. And that's going to be in custody. What I can tell you, felony drug court, they'll probably see him before the week is out. This is run concurrent with 2025 CC 003749. There's $1,000 fine that will be probated. Do you have any children?
I'm probably maybe, yeah.
What do you mean maybe?
Because my girlfriend tested positive, but we're gonna go to the doctors.
Okay. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes is complete, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. There's to be no driving without a valid license presented to probation. There's going to be 20 sober support meetings in 20 days upon release. Proof of employment within 45 days of release. no employment as a home healthcare provider with minors. How are you supporting yourself?
I work with my dad in landscaping, but it's not really a consistent job. It's just
Okay. How far did you go in school?
GED.
All right, what are you planning on doing with your future?
Or I'm looking forward to doing an electrician.
An electrician? Okay. All right, I tell you what, if you complete your electrician school, well, you know what, I'm gonna give you some incentive. I'm gonna actually have community service hours be 200 hours. 100 hours will be deducted upon completion of parenting classes. The remaining 100 hours will be deemed satisfied upon any type of certification. Probation, is there anything else?
No, Judge.
All right. Let me ask you, does he have any felony convictions?
Not to my knowledge, Judge.
Any? All right, so instead of finding him guilty probation, I'm sorry, I don't want this to interfere with his ability to get his certification. So I'm going to do 6 years deferred adjudication.
Yes, Judge.
And Judge, he is grateful for that. This is my request. Would the court be in a position to do his TAP out of custody?
No. And what I can tell you, the felony drug court, they'll have that done before the week is out.
Okay.
All right. Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you, okay? Thank you. All right, court is calling 2025 CR 013879, State versus John Simpson. Can I have parties announced?
State.
Valentina Kokura, on behalf of Mr. Simpson.
And are you Mr. Simpson?
Yeah.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Simpson, did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney and understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Simpson, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Sure.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and he was.
Mr. Simpson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state will take in consideration 2025 PF 22749. Punishment is to be assessed at a cap of 1 year in the state jail facility. The state is opposed to your application. Did you understand that to be the plea? Defense?
Yes,
Is that the
sir.
plea? State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
Oh, yeah.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Judge, you have to state exhibit number 1, including all of its attachments.
No objections.
All right, Stacy, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Your Honor, we would like to reset this matter for sentencing.
All right. Do you want a PSI? It's going to be 12 weeks.
No, not PSA. Your
Oh,
Honor. Just go on his criminal records.
okay. All right, State, do you have criminal history to present?
Judge. Possession of marijuana, 0 to 2 in scope drug-free zone in Guadalupe County. There's a conviction of marijuana in Comal County, 0 to 2. Theft of property in 2011. Shirts. Theft of property in Guadalupe County in 2014. These are all convictions that are on the defense record.
All right. Defense, anything you wish to say?
If we could swear my client.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
John Simpson,
All right, you may proceed.
Mr. Simpson, how old are you?
34.
Are you gainfully employed at the moment? Are you planning on being gainfully employed?
Yes.
Or what are your plans regarding the employment?
Well, they just get me out. My boss didn't come in.
Okay, nobody can hear you.
Excuse me?
No one can hear you. The court reporter is struggling to hear you. I cannot hear you.
Can you speak up?
Getting a job,
What kind of job are you planning on getting?
construction.
And have you been employed in construction before?
Yes, I have.
For how long?
About 7 years.
And do you think you can get a job in construction?
I know.
Okay, and are you married, a single? What is your
I'm
status?
single.
Do you have any children?
Yes, one.
Okay, how old? Child?
It's 10.
Okay, and why are you asking the court to grant you probation?
So we can get out there and be back with them
Okay,
as soon as possible.
good. Where is the mother of the child?
She's in Temple, Texas.
Okay, and the child, where is the child?
In Temple,
Okay, and who has the custody of the child?
the mom.
The mom. Okay, but you want to be there for your daughter, correct?
So,
The son. Apologize. That's all I have, Your Honor. As the witness.
All right.
Ask the question, Judge?
Yes.
John, can I ask you a few questions?
yes, sir.
So, okay, so you said you have a 10-year-old? Okay, boy, girl, boy. Is that your own child?
Yes, my own child.
Okay. So I saw in the past that you had a few marijuana convictions. Have you ever smoked marijuana around your child?
No.
Okay. What about methamphetamine? Did you have it in the car with you that day?
Yes.
Did you take your child around that car?
No.
Who's the child usually go with?
The mom.
Let's talk about that theft that happened afterwards, man. What was going on there?
Theft?
Yeah, the theft that you got a month after you got.
I was with a friend
Okay.
at a academy.
Okay.
And apparently they were looking at him, and we both came out at separate times.
Mhm.
And there was a raid, some kind of stolen raid thing they had at the academy that day, and they hit us both. We were walking out separately.
Okay, so you weren't a part of it?
No, I mean I went to jail for theft, but we weren't. I wasn't with. He was one. It was his how you say stuff. We were coming out and he took the rap for it. What I understand.
Oh, okay. Okay, let's talk about those because two more convictions in your past. One from Shirts and one from Guadalupe.
What happened there, man? One was a possession of stolen goods. Okay, why'd you have stolen goods on you? I pawned a computer laptop that I didn't know was stolen. Okay, what were you pawning it for? I need some money. Okay, you need money for groceries? Yeah, groceries. Oh. So, but wait, if you didn't know it was stolen, then why'd you take a rep for it? I didn't know it was stolen. I would also wasn't part of it. But you were convicted of it. You were found guilty. Let's. No, the original charge was a converted habitation. And whenever they found out that I was in school at the time, that the place got robbed, they lowered it to a misdemeanor. Okay. Because there's no way I could have possibly been at school and been at the place where it was supposedly stolen from. Well, let me ask you flat out, man. Are you stealing things in order to feed your head? No, I'm not. Okay. Do you think you have a drug problem? I know I have a drug problem, yeah. Okay. Why do you say that? Because you're not multiple convictions of drugs and I don't have a problem, you know. Have you sought out any kind of rehab or anything like that before? No. I haven't been off of rehab. But if you have a drug problem, then why have you sought a solution or rehabilitation to get you out? I haven't been in trouble for over 10, 15 years. So you're only seeking rehabilitation because you're in trouble? I'm not seeking rehabilitation right now. I'm just trying to sober with the past. So you're not seeking rehabilitation at all? No, I mean, I'm trying to get past it. I'm cool with your drug problem. Continue. I didn't say that. You said that. And so it's cool with it. All right. Thanks, man. Appreciate it. That's what the judge.
Mr. Simpson, are you asking the court to grant you probation? So, if there is a program available to you to address your drug problem, the
Yes.
court would
Definitely.
yes,
I'd be interested in any kind of
participating.
programs or anything that I could do to help me in rehabilitation. Yes.
Okay. Are you interested in maybe drug court? Is not an option maybe?
I don't know what it is.
Well, it's a special program for people that have a drug problem. It's up to the court to consider that if it is possible. Do you want to address your drug problem? Correct, through the program, and do you want to be there for your child?
Yes.
And regarding cases, the state asked you, you did accept responsibility for those cases, correct?
Yes.
And
It's the ones that you previously mentioned, right?
correct,
Yes.
and you did serve sentence for those cases, correct?
Yes, I did.
And as far as the case before the judge, you did accept responsibility for that case, correct? No further questions, sir.
All right. So these are your choices. These are the only two choices you have. Number one, I can grant your application. If I grant your application, you're going to stay in custody until a TAP evaluation is completed. And those TAP evaluation results will be followed. Otherwise, what I'll do is I'll find you guilty and sentence you to 8 months. Which do you prefer?
What was the first one?
You can either, one, I'll grant your application. You're going to remain in custody until a TAP evaluation is completed. If the TAP evaluation says you're doing inpatient treatment, you're doing inpatient treatment. Or I'll sentence you to 8 months. Which do you prefer?
Inpatient treatment.
All right.
First.
Okay. All right, the court will find you guilty taking consideration 2025 PF 22749. There's to be a TAP evaluation in custody, follow recommendations. There's to be a referral to felony drug court. Regular reporting by Zoom or in person. Regular random UAs. No residing in households with minors. No unsupervised contact with minors. And counsel, that will change once he's proven to the court that he can be clean and sober. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Proof of employment within 45 days of release, no employment as a home health care provider or with minors. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court?
That's where it.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any, just 1 second.
Judge, the
Yes, that's what I'm going back to do. I was like, whoa. All right, and also the court is sentencing you to 1 year in the state jail facility, suspended and probated for 3 years. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, what that is, you'll need to speak to an attorney. Do you understand?
Yes, I did.
All right, good luck to you.
Thank you.
You're welcome.
yes.
Lee Saldana.
That's you, Judge.
Afternoon, what is happening with this case?
So I've conferred with the state and my client. I'm going to have to file a motion to have him have a psychiatric exam done, Judge.
Okay. All right,
Just a
Ms.
sec.
Ferguson. On this one, we need psych eval. And if you will recall this in 60 days.
Yep.
All right, we're gonna bring you back, all right? But first, the doctor's gonna speak to you. What date? All right, so we'll be back on May 7th.
Thank you.
All
Have a
right, thank you.
Have a seat, Judge.
And then I think that's everybody.
Yeah.